Today, the last speaker of this session is Mr. Ranjit Thomas. Mr. Ranjit Thomas is currently working as an assistant professor of law and also the executive director of the Center for Child Rights Advocacy and the Center for Criminal Law Studies at the National Law University, Jodhpur. He has specialization in criminal law and is currently doing an extensive research work on the topic of jurisprudence of sentencing in India. His areas of expertise inter include philosophy of criminal law, administration of criminal justice system, and sentencing. He has delivered more than 80 expert lectures on various topics, which include sentencing issues and challenges, admissibility of forensic evidence in criminal trial, and arrest and trial procedures. He has, to his credit, several national publications and has participated in numerous professional training programs, conferences, workshops, and seminars, and has conducted a few by himself. In 2018, he was selected as a visiting scholar to Faculty of Law, University of Oxford. In the same year, he was nominated as an expert for providing legal and technical support to the proper implementation of Integrated Child Protection Scheme, Juvenile Justice Act 2015, in the state of Rajasthan. Currently, he is a visiting faculty at Rajasthan State Judicial Academy and Internal Security Academy, Mount Abu. He is also associated with several judicial academics, Intelligence Bureau, and Bureau of Police Research and Development. So, sir, we are very delighted and pleased to welcome you in this platform. And I hand over the session to you, sir.
Thank you so much. Actually, I hope I'm audible.
Yes,
Am
sir,
I
you're
audible?
audible. Yes, sir,
Thank you.
you're audible.
Thank you. Why I switched off my, video because I think there is some, I think connection issue is there. That is why because I'm facing difficulty to log in through my laptop. So I'm logging through my mobile phone. That is why for the bandwidth, I'm switching off my video. During question and answer session, I will switch on the camera. Is it okay?
Okay, sir. Yes, sir. No problem, sir.
Thank you. Yeah. So uh, I was, intentionally listening to the earlier two speakers. To an extent, a person from law. The first one, to an extent, I am aware about, about the gender methods and we used to commit while uh, writing things and everything. So why I said these two speakers or their content, because we are going to deal with a completely different issue. Because when the first speaker beautifully discussed about the method and methodology, the second speaker discussed about the importance of language in writing. So from this premise, I am, completely shifting, my discussion to a new, you can say terrain in which how the legal research, when it comes to, analyzing it with blue book citation about, plagiarism, especially my whole issue is about originality and about justifying what we are writing. So if you see, so I think I'm so sorry because my entire premise will be, the edifice will be on legal research and in relationship with blue book citation and everything. What are the issues mainly people used to commit when they are using blue book as a citation for legal research? So uh, if you see the whole legal research about the meaning, objective, methods, and everything. Even just take the types, even types of research. When we have multiple types of research which we used to follow, like descriptive, sometimes analytical, applied, fundamental, quantitative, qualitative, conceptual, empirical. Why? The whole aspect is why we are employing. We used to discuss more about research methods, methodology, the relevance, at the same time interchangeably we use the word purpose, importance, and everything. Actually, it is more about the output. So the second speaker was discussing more about, the language. So I was, unconsciously, or, you can say, thinking about, I used to read a lot from legal literature, but I'm so sorry to say that 95% of what I'm reading is recycling of what is available in the domain. But language is extremely beautiful. So the whole question is coming into picture. What is the purpose of research? Whether, what is the function which these, and just take it, 95% I'm saying, from maybe because of the materials which I am reading, maybe, the similarities of 95%. When I'm saying 95% is recycling, the problem is coming, see, at the same time, out of this 95%, near about 50 to 60% is having, beautiful language. In the sense, you can see, like, when it comes to the construction, when it comes to, the way in which coherence and everything, it is perfect. But the problem is coming relating to the originality. Second issue is coming relating to, so see, on one side I am discussing about originality. At the other side, or on the other side, my issue is mainly relating to how they are citing, especially about when they are giving their personal opinion. It is not their personal opinion. That is not the major problem. So why I said about, when, especially when it comes to the legal research about, the different types and everything, actually the purpose of all these things is to about, the report, or the, output which we are creating. So when we are creating an output, you can say whatever be the thing, like, writing an article, or writing whatever be the thing. The whole issue is relating to, when we are writing something, the most important is how we are citing it. So when I'm saying legal citation, I am unconsciously taking or discussing about the purpose of legal citation. If you see the purpose of legal citation, mainly we can say it is threefold. The most important is the first one. You can say that it is to indicate that, we are relying upon some authority. Okay, so we want to show that, okay, this is the authority which I am relying. And if you see the second, that is to identify the specific authority relied upon, and to show the readers its weight or persuasiveness. I will explain both the things. First, I was discussing about, uh, authority. Second, I was discussing about the weight or persuasiveness. And the third one is to show the source. You can say, because to provide an easy way to locate a copy or the source of the authority. Because, normally as a reader, you just take you yourself as an example. Sometimes when I am reading article, I used to be romantic with the footnote sometimes than the content. Why I'm saying that, even foreign articles also, when you try to read from, Oxford Journal for Legal Studies or anything, sometimes we can see that the citations are beautiful. I think that is giving more insight into our research, or getting more, insight into the arguments which we are trying to strengthen with our own analysis and everything. So it's very important to locate the source or the copy of the authority. So that is what is, or you can say, one of the most important function or the purpose of legal citation. So if you see, the first purpose of the citation is, you can say, to let your reader know that, okay, the statement you have just made is based upon authority. The why aspect is, if you make an assertion about the law and do not immediately follow with a citation, your reader will assume that whatever wrote is your personal opinion. This is what the issue. If there is no citation, we have only one way to come to a conclusion, that is your that author's personal opinion. That is why we used to say that the good legal analysis is based on law, not personal opinion. Because we don't want personal opinion until and unless it is not backed upon some authority. Sometimes even I used to say this to my students also. Who are you to give personal opinion? That is the issue. So we can see that if you try to focus on the first one, mainly in that function, it tells the reader that the statement is backed by authority. But if you try to dissect the second one, we can say the second function, we can see that the function is to identify the authority. The person is, relied there and indicating. whether it fits with other roles of authority. For example, that is a peculiar situation with legal arena, because in legal arena, all authorities are not equal. For example, some authorities such as constitution or the Supreme Court cases are usually more important or persuasive than, you know, especially when it comes to Supreme Court cases from other authorities. So in this situation, the citation will tell the reader exactly where the authority fits into the pecking order of all authorities. And if you try to see the third one, that's the third purpose of the citation, is to provide all the information needed to quickly locate the cited authority. So why? Because when it comes to legal arena, there are millions of different authorities a person who is doing legal research can cite. For example, cases, statutes, regulations, treatises, legal articles, so on and so forth. That is what you can see that the main problem with law, because obesity of authorities are there, according to me. Obesity. I'm with a capital O, I'm saying obesity of legal materials. Okay, and if you see the law libraries, I think right now in last uh, you know uh, 5 years, I think we are having completely debunking the old system of law libraries and everything, completely going into online things. Even I personally visited a library, I think some 3 years back or something, because even the books are online, available online. So if you see the, you know, uh, legal citations point, it helps the readers straight to the original source, enabling them to go directly to the specific book if it is in the library, or to just make some click and open the exact spot with the authority where you obtained the information. See, I think how I am using the word information, I'm intentionally using the word information because sometimes, information and knowledge, that is what my issue. Sometimes in beautiful language, we can share information, but you can't generate knowledge. But sometimes even with uh, 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 errors in the language, you can generate knowledge. That is what the most important thing. So why I'm saying information, sometimes my research will be an information to the other person. That is what we used to uh, if you try to dissect the whole concept of hypothesis, we will realize that sometimes even a prior research is becoming uh, a source for his own hypothesis. That is why we used to say it's an information. There it is not a knowledge, it's an information. But at the same time, when I am writing it, it's a I'm generating the knowledge and everything. So why I'm making stress on this citation about the errors which we used to commit regularly. When I'm saying errors, I will point out that how that errors are coming into picture and everything, especially when it comes to the citation. The issue is that mm, uh, most of the generation of knowledge, or you can say the other way around, what we are trying to say it is we are generating the knowledge is information wrapped in a beautiful label. That is the thing. So by especially in legal arena, by taking care of these issues, like how we are citing a sentence or a clause or an embedded citation, we can to an extent reduce the I'm not saying plagiarism, but the problem with relate to originality to an extent. So if you peripherally see, these are the main way in which, or we can identify the purpose or the function of the legal citation and everything. But then if you try to ponder upon the whole issue relating to when to cite, that is the most important thing, because why is one, at the same time the when is also very important. So the basic rule relating to when to cite is saying that you should provide a citation for anything you take from any any type of, whether it may be a primary authority, secondary source, or other publication, or any other thing. So that means cite anything you take from, because if you see the legal arena, if you just take a case, recently I was I'm just sharing my personal experience. I was reading a case analysis. For example, you just try to see the way in which that case analysis means he is writing after analyzing a case law. he's writing. So I will make a fictitious one. Why I'm saying that I will make a fictitious one? Because otherwise, I don't want to reveal the author or anything. Just think about this. This is the paragraph. Okay. uh, Aravind Murthy was employed by State Bank of India, mm, and when he was mistakenly arrested and charged with making fraudulent withdrawals from the bank. Full stop. The withdrawals were actually made by another SBI employee with the same last name. Full stop. Aravind suffered no physical injuries based on his arrest. Full stop. The court held that the Indian law does not require that the plaintiff suffer a physical or mental injury to sustain an action for false imprisonment, that is an interference with the liberty interest, is all that is required. Full stop. Then like that sentence is going. What is happening? Okay, this first paragraph, he is, we can say it is in his own language. In his own language, he is explaining that, and in the last page, he is putting one and he is giving the footnote. Actually, the problem is that if you read Blue Book citation, Blue Book is clearly saying that for each sentence you should cite. That is the issue. Because when you are writing the first sentence and when you are putting that full stop there, automatically the first footnote is coming there. That will be Aravind Murthy versus SBI 1995 3 Supreme Court cases, page number 467. It's immediately coming there. The withdrawals were actually made by another SBI employee with the same last name. There, when you are putting the full stop, the second footnote is coming there. That is, that when we will not repeat the same thing, so we will put it again, it. Then we used to write, if it is coming in a different page number, it at page number 420, like that. So the whole issue is relating to these are the small errors which we used to commit when it comes to the originality, and how through legal citation, especially Blue Book is one of the citation. We have multiple citation things. So in this lecture they give me the tool of Blue Book to analyze this whole issue. So if you, again, I'm going back to, when to cite. So in that, I told you that if you cite anything or cite anything you take from, that means sometimes it may be cases. So it's not about simply cases. Cases consist of facts, rules, holding, explanations, dicta, or any other information or idea if you are taking directly from a case. That is why the most important thing right now, you heard about right to privacy. People are writing in detail about right to privacy, but if you see, most of the time their ideas or their concept, or they have an intellectual indebtedness to Puttaswamy versus Union of India. Or why I'm saying Puttaswamy? I mean, Puttaswamy, we clearly held that right to privacy is a fundamental right. Or if you try to see earlier, Karak Singh Pe, how the court interpreted, uh, you know, in multiple case laws are there, but these people sometimes they will say just somewhere just a name of Puttaswamy. But if you see most of the places when they are discussing about any of the things, they are indirectly, unconsciously, the silence of that paragraph is that. So that is why I said, when we are saying about cases, it includes all these things, especially statutes. Statute means, for us, Indian constitution, or other codes like Indian penal code, all these things, procedural law, and all these things, administrative rules, whatever, any other legislative source, all these things we will put it under the ambit of the statutes, or any other secondary material like books, commentary, illustrations, explanations, all these things, or even newspaper, non-legal publications like newspaper, video, internet, or any other source. Most of the time, after listening to a lecture and everything, nobody is citing, because they will be watching something and they will be getting an idea, because right now almost all the lectures from abroad are available, so they will be getting an idea conveniently, because it's not there in the textbook. So conveniently we will be uh, keeping a silence there relating to that video. That is why. So it's not only non-legal publication, it's about facts or other information, whatever be the thing. So it is the duty of the author when it comes to legal citation to cite. And that is why I told you, if you try to analyze this whole citation, legal citation, its importance, the main place where we are overlooking while writing is the difference between citation sentences, citation clauses, and embedded citations. If you read a Blue Book, 1.1 is in detail discussing about this. So first we should try to, so please keep in mind one thing. So when I'm, dropping the sentence, like words like citation sentences, citation clauses, and embedded citations, because sometimes when we are writing one sentence in our own language, we are, that is from some, just think about from a case, we got that idea and we are writing it. But sometimes when we are making a sentence, we are getting idea from two cases. At the same time, when we are saying something, it is directly coming because the ratio of the case is that. In that case, the court held that. See how that is becoming different. So that is what, so I think, I'm having a rider that is, when I'm dropping these sentences, because, even we have the time restrictions also. Already it is going to be 8. Another 30 more minutes is, I think I'll take only 20 minutes. So, uh, if you're getting these, you know, words, this is more than sufficient because you can do your own, small research because, when it comes to research, it is by, learning by doing. And don't take it like a lecture or anything. It is, I'm just sharing my experiences and, my observation. So it's about learning by doing, and, you can, you know, your own, do a small research and identify the importance, how indirectly citation clauses we are converting into citation sentences, and conveniently embedded citations into citation sentences. So first, I just let me explain the difference. See, you know mm, there is a key difference between how academic writers, you know when we used to write law reviews, articles, and everything, how we used to cite, and the practitioners means the people who are practicing in the court while they are preparing their documents, because they also try to prepare beautifully the documents and everything, and they will submit it before the court. The best example is, you will get, if anybody who is interested, just go for the submission of the councils in Joseph Shine versus Union of India, that is about making adultery unconstitutional. If you read the submission of the council, it is like a literature. They did superb research, because why I'm, citing it as an example, because one of my student was a part of that research and everything. So she shared, the documents with me. So I was perusing it. They did a beautiful research. How, the jurisprudential foundation, how it is in violation of, constitutional rights, how certain rights which were already established by the Supreme Court is blatantly, in conflict with the existing provision of the IPC, that is, making criminalizing adultery, how the other jurisdictions responding to these things. So multiple things will come into picture. So what I'm trying to say, when they are, you know, mm, submitting a document, there also citations will come into picture. So what I am trying to say is that, uh, when it comes to academic writing, we used to place citations in footnotes. But sometimes, most of the time, these practitioners incorporate citations into the text directly after the proposition they support. That is to an extent good, because that court will, never, because if you're saying something, immediately the court need whether what is the backing, what is the authority for that. So immediately after, you know, writing uh, the text directly after that, no, after the proposition, they will put the footnote from where, you know they are, relying and everything. So uh, if you see in a citation sentence, the most important is that, I think it's the most preferred method of citation. If you are writing something, and when a citation supports the entire sentence, place the citation after the text. That is what the citation sentence. So if you see, the citation sentence begins with a capital letter, and uh, and has a period at its end. Why? Because it is its own complete sentence. That is the main thing. So if your sentence if your entire sentence, if the citation which you are having supports the entire sentence, place the citation after the text sentence. That is what the most important thing. So when it comes to citation clause, I already told you, because uh, in a single sentence, or when you are writing a sentence and your single sentence is supported by two or more authorities, the problem is that whether we are unconsciously, I think, whether we are thinking about that, when we are writing something, even that sentence is supported by multiple authorities. Normally, we used to do only one thing. We will just make, for the sake, because the purpose of our citation is to just show that, okay, we are citing. That is what the purpose. But why I am saying this thing? I got a bad experience when in the year 2018 I went to abroad for doing some research and everything. So there I got an opportunity to attend uh, seminar. It's not a seminar, it's a workshop organized by Oxford University Press in collaboration with uh, University of Sydney and Faculty of Law, University of Oxford. I'll tell you, the first thing which I did immediately after that is thinking about whether I should continue with my PhD or not, because whatever I did, whatever I wrote, because in complete violation of all, no, okay, we are putting citations, we are doing things and everything, but to what extent, these things? That is why if you try to, and I'm just, I don't know whether I'm narrowing it down only to the legal field. Just try to see how many of the Indian academicians, especially from law, are publishing on peer reviewed journals abroad. I'm not saying nobody is publishing, but it's very less. The problem is that they have you know they don't trust. That is the main issue, because they have problem with our research. First of all, just take about our methodology. Then comes even when it comes to even our output, research report and everything. Sometimes that can be an analysis or an article or a project report, whatever it may be. They have the problem because actually we used to take these things taken for granted. That is the issue. So uh, at the same time, in a citation clause, I told you that within a textual sentence, uh, uh, or okay, I'll leave within a textual because I think I'll make it a bit more simple. The citation clauses are most used, commonly used when a single sentence is supported by two or more authorities. So what we used to do occasionally, when one part of the sentence is from an authority and another part is the application of the authority, we used to put a comma there and we used to put the citation there. That is why uh, mm, when the citation supports only part of the textual sentence and the authority is not an integral part of the sentence, please keep that. If it is that the authority is not an integral part of the sentence, then set the citation off from the textual sentence with commas. Why I'm saying that? If it is an integral part of the sentence, we should use embedded citations. That is the most important thing. So this is a minor, it's a minor thing. But what we used to do, we won't, be, I think, when it comes to embedded citations, what we used to do, we used to place comma before the citation. But when a case citation is embedded into the textual sentence and it forms an integral part of the sentence, then what Blue Book is saying is provide the citation followed by a comma. Do not place a comma before the citation. Okay, so I'm just saying these things because these are the things which I usually see when it comes to uh, recently I was in the peer review board of sage journals. So the issue is that this is with almost all the places. It's not particular to Indian scenario or anything. It's with almost all the places. Okay, so I think uh, just keep in mind about how to use uh, uh, citation sentences, citation clauses, and embedded citation. If you are having a doubt, don't worry. Think about it is an intentional, it's an intentional thing from my side. Because if you read a bit more, try to find answer to that question, you will get absolute clarity. The best way is that, okay? But don't forget about the minor distinction, though that we used to say it is minor, but it's a major one. Then then comes, one another important thing which I used to observe, that is about pinpoint citation. Why? Because we don't do this pinpoint citation, or we used to say the other word is pin cite. It's discussing in rule number 3. That is, yeah, I'm sorry. See, the purpose of, we already discussed that. The purpose is to provide the reader with the information. See, a reader with the information necessary to locate the cited authority. You can say the source or the place where we can find that material. See, that exact place is called a pinpoint or a pin site. I'm telling you very frankly, most of the time, even personally, I used to face this difficulty because it's difficult to pin site or pinpoint that exact place. So, uh, when we are writing, except when referring to an authority in general, please provide the specific page, section, or paragraph number, footnote, or supplement where the cited material appears. So you can say the method used to pinpoint depends upon the specific authority which you are citing. That is whether it's related to a primary material or a secondary. Even under the secondary one, under what category it is coming into picture. That is why I said sometimes it can be page, sometimes it can be section when it comes to a statute, treatise, or authority divided into multiple sections and everything. Why I said page, because sometimes we used to cite one or multiple pages of a case, book, article, or any other paginated authority. I think sometimes we used to cite normally if you read especially legal literature from abroad, we used to get this lines. So when it comes to lines, one or multiple lines of paginated material, we used to pinpoint that, okay, to that specific line. Sometimes we are quoting on one or multiple paragraphs or even sub paragraphs of material divided into numbered paragraphs. 2.1, 2 point, if you see Holsbury and all these things, it is you can say multiple paragraphs or sub paragraphs of it divided into numbered paragraphs. That is the issue. Sometimes footnotes. Sometimes we used to cite one or multiple footnotes. Sometimes endnotes, not one or multiple. Sometimes supplements. Supplements means the material appearing in a pocket part or supplement. We used to do that. But if you try to see rule 3.2 clause A, it is discussing about if you are citing a page, how to cite a single page, how to cite multiple page, even in multiple consecutive pages. Because most of the time I used to see that they used to write 600, like 453 and 454. They will simply write 453, then um, hyphen or an n dash, then 454. I think it's wrong. As per rule 3.2a, it should be 353 hyphen 54. It should not be like 350. No, it's a minor thing. But then if it is a multiple non-consecutive page, it should be like 354, 353, then 356. There you can't write 353 comma 57 or something. So even I find it a bit weird, even when you are citing a first page where they are saying that you should uh, the pinpoint, you should not even omit if it is repetitive. For example, 1993 3 SEC 651. If I'm relying on the first page, again I should put a comma and I should write 651. So I think elaborate rules are there relating to pages. So please, specifically go through. It's a bit complicated, but when we are trying to, do an exercise in a serious format, when it comes to legal research and everything, we should be thorough with even, the page when it comes to first page or multiple consecutive pages, single page, multiple non-consecutive, first page, all these things. Even, just think about footnote. I'm just throwing, I'm from, that is, I'm directly jumping from pages to footnote. What about a single footnote? Sometimes, we used to cite with page and footnote. See, one, we are directly citing a single footnote. In another situation, we are citing with a page and a footnote. Sometimes consecutive footnotes we are citing. Sometimes we are citing non-consecutive footnotes. So I'm just introducing this thing. There comes, uh, we used, the small letter n in an, inverted comma, and the footnote number we used to write and everything. So why I'm saying that, please keep in mind this when we are citing single footnote. Just go through rule number 3.2 clause B. Beautifully explaining, elaborately explaining, if the cited material appears in a footnote, first cite the page, comma, section or paragraph number of the text where the footnote reference appears, followed by the abbreviation n and the footnote number, and no space between the n and the inverted comma. I think, and even, when we are saying there is no space between the n, even, you know, even with the footnote number, normally we used to give space. That is the issue. So these are the minor things when it comes to, cite legal research and citation. So I'm not explaining all the things. Please try to see how, when a page and a footnote is coming, when consecutive footnotes and non-consecutive footnotes are coming into picture. Even the same thing with, end notes also. If it is a single end note, if it is a page and end note, it's saying in a different manner we should cite it. The same thing, like, when it comes to space and everything, between the n and the end note, there will be no space. But when it comes to page and an end note, just I'm explaining for the end note how to cite page and end note. If you want to cite material appearing in both the text and then, and you can say in the end note, include the page number of the text where the material is found, followed by an and, that's we used to say ampersand, the page number where the end note appears, the n abbreviation for the end note, and the end note number. So this is what we used to do. This is this, to an extent for the supplements also, we used to do the same thing. Then comes, short form of the citations. Uh, why I'm saying this short form citations and everything. See, in full citation, it's, that it contains all the information. Yeah, a reader or a person who is, seriously approaching that need to determine the source of the cited material. Okay, so depending on the source which that person cited, full citations sometimes can be long and cumbersome. Why I'm saying this thing, just try to see articles written by H.L. Hart. You can see that even not only H.L. Hart, even some recent scholars also, I think. Just a minute. I think Edward and Gardner, all these people, you can see in a page only 2 sentences will be there, rest all will be footnote. That means 95% of the space of the page will be occupied for, footnote, and only 2 sentences there. See, so the whole issue will come into picture. That is about multiple footnotes are coming. We used to say speaking footnotes and all these things. But what I'm trying to indirectly convey is, depending on the specific source cited, full citations can be long and cumbersome. So as a partial solution, this Blue Book allows the use of shorthand citation forms of repeated references to the same authority. Okay, so you can say rule number. It's mainly discussing in rule number 4. Okay, so I think they're using that it, that is idem, which means the same. So uh, uh, it can be used to cite the same authority as was cited in the immediately preceding citation. Okay, and sometimes it is always underlined or italicized. So but pinpointing the same page or section, that is another different thing. That is a different rule. That is, if when the cited material is found on the same page, see, when the cited material is found on the same page, or you can say, mm, in the same section sometimes. okay, as the immediately preceding citation, then there is no need of adding pinpoint. So no pinpoint is required in that situation. But when different page or section, there comes the issue. Means when the cited material is found on a different page or in a different section than the immediately preceding citation, include a pinpoint. For example, like id. Okay, you're citing something. I'll give you an example. Id at page number 578. See, id at page number 578. That is what the same thing will come with, the supra and everything. It's about, when it comes to even supra also, that. I think when it comes to supra, almost all the people know that we used to, use regularly supra. What to convey? I'm just trying to map. I think it's going to be last 10 minutes. Okay, just give me one more minute. So it's more about when we are trying to analyze it with Blue Book. I'm not saying Blue Book is the best one, because why we are following Blue Book? Because most of the approved journals are asking for citation in Blue Book. The purpose of citation, I told you that if it is Blue Book, APA, or Scholar, McGill, whatever, I told you that the function is same as that of what we discussed in the first part. That is to indicate that you are relying upon authority, to identify the specific authority, or to show that weights or possessiveness, and to provide an easy way to locate, okay, the source or authority or something. So why I said, irrespective of the citation and everything, it's more about, the integrity. And it's more about that serious exercise of bringing originality. So that is why I was, indirectly connecting it with the first speaker. First speaker, was beautifully discussing about the method and methodology. And the second person is, beautifully discussed about, the linguistics, the language. But the problem is about, in academics, whoever is from, whatever be the, stream, it's about originality. So according to me, one of the major tool in which we can bring originality to the, output which we are, producing or we are creating, is through giving proper citation. You can use whatever be the citation. There is no issue according to the, the place where you are submitting your research, or your publisher demanding whatever citation. But it's a serious exercise, not for just for the sake. It's having, and we can say meaning, silence, and relationship. The silence and the relationship of, the serious exercise is bringing originality to what we are trying to create. I think then only the real creation is happening. Otherwise, we will be recycling what is available in the domain, like, passing the information. Thank you so much.
Thank you so much, sir, for that very informative, interesting, and insightful session. It was wonderful hearing from you about, you have stressed upon the multi-type of research, and then the legal research, and what is the purpose of legal citation, whereby you have stressed that it indicates that we are relying on some authority, and since we have different citations to follow, and to locate the source, and whereby you have stressed also on the, you have highlighted also the statement is backed by authority, and the function to identify your authority. And when you talk about the Supreme Court cases from other authorities, the statutes, the legal articles, how to cite the citations, and you have also stressed upon the Blue Book, right, where each sentence you should cite. And You have also stressed on, mainly it was really interesting to note that you have also shared your personal experiences and observations. So those are something which is very valuable, whereby only through experiences and observations, you have shared with us, and we have learned a lot from you, sir. And you have also, you have also spoken about the footnotes from where the sources are, and also the consecutive and non-consecutive footnote, and those pinpoint citations and pin cite, and then the endnotes, and then how to cite the single page and how to cite multiple page. So it was very interesting, mainly for me, mainly the experiences and observations which we all learn from you, sir. So thank you so much for the beautiful presentation, sir, and we really appreciate that. You know, uh, in the future we shall learn more from you. We shall meet, and in this particular platform, and we'll learn and have more interactions with you, sir. Um, okay, if there is any question from the chat box. Yes, no questions from the chat box, but okay, there is one. Okay, sir, there's one question here regarding citations and footnote. It says, "Is it MLA 8th edition is enough, or or do we have to follow Blue Book rules for a research paper to publish?"
Yeah, it's a a nice question. That is why I told you. Normally, what per my personal experience, I'm telling you. Normally, actually, I completed 1 decade in this profession. So right now, I used to write only when people are demanding. Why? One thing is that then first thing I will ask them, okay, what citation you need. So it is better to ask to the, for example, if you are doing PhD, ask the supervisor regarding the citation, because otherwise don't follow anything. It is the supervisor to decide. Even I'll tell you one more thing. Even in Blue Book, local variations are there. So they used to say only consult with the supervisor and to follow that. Even there is small difference between practitioner citation and academic citation. So that is why I'm saying that when you are citing something, I told you that first part way, the purpose or the function of the citation is the most important thing. What method we are following is more about the institute, about the if you are writing it for a journal, what citation they are demanding. So there is no issue. And I just want to say one thing very personally. Most of the time, what we used to do, this citation is a simple exercise. Anybody just try to read this Blue Book. It's a complicated one. I'm telling you, complicated means extremely complicated. At the same time, just try to see that in law we have one ILI citation, Indian Law Institute. It's very simple. So the problem is that I'm saying that it's more about, but there should be a uniform citation. Please keep in mind that there should be a uniform citation, and that citation you can decide in consultation. If you are a research student, consult with your supervisor, or if you're writing for a journal, consult. It's not consulting. They will immediately mention that this journal is following this. For example, some journals are following Blue Book 20th edition, some are following Blue Book 21st edition, some are following MLA, APA, OSCOLA, or anything. So according to that you can decide, but don't forget about the purpose or the function. That is what is more important. Thank you.
Yeah. Thank you, sir. So any from the participants who have questions, they can unmute themselves and ask, sir. Anybody from the participants? Anybody else? They can unmute now and ask questions. So I guess nobody has any questions anymore. They are all, they have clarified with their doubts. And
One
um,
second.
yes,
Actually,
yes, sir. Yes,
as
sir.
anyway, we are concluding. 3 minutes are there. That is why. Please try to see, the difference between information and knowledge. And every time, please keep in mind when we are writing something, whether we are sharing information or we are generating knowledge. If we are keeping that in mind, I think to an extent, we can solve all these issues. Why I'm saying that? Unconsciously, if we are, you know, following this citation, to an extent, we can minimize this and we can, lean towards the other side of generating knowledge and everything. If at least, that is why I used to say that writing 300 page or 400 page, उधर पे कितना percentage originality we can expect in that. Just think about that. So just I'm saying the difference between information and knowledge. Under what circumstance sometimes information can be termed as, knowledge can be termed as information. Whether we need information sharing or generation of knowledge, what is the purpose of higher education in which we all are, being a member. Thank you so much.
Okay. Thank you so much, sir.